Good evening. You are live with Lawman.
And Carmen B.
And again, we are here at Courtside to discuss your criminal law questions. Any questions that you have about California criminal law or constitutional law, we are prepared to answer.
And we can discuss other things too, things that affect society, like voting rights and things like that are hot.
And current events.
Yes.
We would like to remind you that if we do answer your legal questions, that it does not establish an attorney-client relationship between myself and anyone that calls in or Mr. Staten and anyone that calls in. But our purpose is to educate and inform the public.
Yes. And enlighten.
Yes.
Definitely. So I think we're wide open tonight, Carm, right?
We are. So we're going to be taking questions as they come in from callers and in the chat.
Yeah, throw us a subject matter or two. But I'll tell you something hot in the newsreel. Major League Baseball just pulled the All-Star game out of Georgia because of the voting rights acts that Georgia has been passing, or lack of voter rights acts, should I say?
Or yes, actually, it's laws that basically are trying to hinder voters, and particularly African American
Right.
voters. It appears that there are legislators in Georgia who are very upset about the outcome of the last election, not only the presidential election, but also the Senate election that was occurring in that particular state. And so what it appears that they're trying to do is and they did, is pass a law that will actually limit people in terms of their ability to vote.
Yeah.
One of the things that I thought was really odd was that you will not be allowed to give food or water to someone who is standing in line to vote. And that just seems quite ridiculous, since we know that a number of people had to stand in line for hours and hours and hours at a time. And especially with older people voting, who are going to require some kind of sustenance.
And assistance and everything. And when you think about that, you got to wonder, what are you trying to do? What is this bill trying to do? What is this law trying to do? And when you deny that simple service and make it criminal, it harkens back. You know, I feel like I just woke up and it's maybe 1949, somewhere around in there somewhere.
But here we are in 2021.
And the real harm is that, is this a backlash? Is this what happens when we assert our rights and we vote people in that we want to see? And is this the way they respond?
This is apparently the way that they are responding in Georgia.
Yeah, and all over too. There are other legislators in different states who are doing the same thing, and that's why Major League Baseball has got to.
But they has it passed in any of the other states?
I'm not sure. Yeah. Up for election. Yes. For a vote. Yes. So I think baseball is going to lead the way. They mentioned that, you know, they're trying to be like the NBA and WNBA in terms of social consciousness. They realize that the majority of their players are Black or Hispanic, and that they need to do something about the social issues of today. They're encouraging the athletes to speak out, which is just great, because they used to do that. You know, I mean, we had these athletes that did speak out, and they ruined their careers basically by doing so. I mean, John Carlos and the other brother, who the track athletes in 1968, when they organized that boycott. You know, it was a beautiful thing to see. One person, Wilma Rudolph, I think, even. There's been so many. Curt Flood, definitely in baseball. You know, I mean, his career is pretty much gone. It's similar to a Colin Kaepernick today. Very similar. You know, once they stood up, then they got ostracized. You know,
doing it for what is right. Yep. And one of the problems that we see is that no matter how we decide to protest injustice in the United States, we're told that it's not the correct way.
For other groups and things, they can take that idea and then it becomes an American way. They're doing their thing, the gun rights or something like that, right? So it's heartbreaking in a way to know that this kind of backlash is there, it's out there, and that it comes at times when if we're not watching and being very careful, because I just tell people, well, we can talk about that tonight even. The Supreme Court, how they have swung, through the years, one way or the other.
Well, now, because of the last presidency, I believe he placed three. He was able to appoint three separate justices.
Yes.
One president appointing three separate justices to the Supreme Court.
Yeah.
And of course, those justices are justices who are very conservative,
like-minded,
in their thought process about the law and about the Constitution, and therefore their interpretation of the Constitution is going to be different.
Right. Maybe they're trying to make America great again, or something like that. I mean, the irony is
I'm still not quite sure what that "Make America Great" really means.
I'll tell you this though, all I could think about was I have to go back to 1919 in Tulsa, where, and even before, you'll find in the early periods of Reconstruction, after the war, after Emancipation Proclamation, after 13th, 14th, 15th Amendments were passed, that we, Black people, were sort of left on our own. And it was good because we weren't voting then. We had the right to vote then. And we took action with it. We voted people in anywhere we could. Which is why it was so important in the 60s to try to maintain it and keep it. And the vote in a democracy is extreme power. We know that what has surpassed that, or at least what we believe has surpassed that, is money poured into the ability to vote, and therefore people getting their way. But that vote itself, because anyone can check, you can check history, and you can see that what we were doing in the Reconstruction period, were building cities, towns, communities, all over America. And the one big difference, the one big thing that bothers me is, well, what did they do then? They bombed us, they stopped us. They could use physical violence and wipe out city boards, anything. Today, the difference is, and this is why it's so important to vote, because you got to think of it this way. If they're willing to do that in a democracy, to wipe out your real power of voting with violence, well, there must be something really valuable about that vote. There must be something that has to be cherished about that vote. I wish we looked at voting as a people with the value that we would even just look at being a rap artist. If it was that, if it was something that we all cherished and could exercise it.
I think one of the problems is that what has happened with voting is that, in America, there are two major parties, and it's the Democrats and the Republicans. And African Americans tend to vote for the Democratic Party and Democratic Party candidates.
Now, yeah.
More so, well, yes,
yeah.
More so now in the last years than they do for Republicans. Now, the vote is supposed to be worth something, and not in the way in terms of selling it, right? We're not talking about the vote having a monetary value on the actual vote, but what we're talking about is that there should be policy that you get from your legislators in exchange for the fact that you voted for them. We see other groups that get policy specifically related to their needs. And from the Democratic Party, it's unfortunate we have not seen that. Now, we're hoping that in light of all of the things that have happened in the last few years, that we will see a turnaround. But in order for that to happen, we must, as voters, demand that policy. Because there are people who are not citizens who get policy. And so certainly we, as American citizens, are entitled to policy that affects our needs, that affects our communities.
True, in our interest, so to speak.
Now, I do have a question, and as we said, today is kind of a free-for-all for you to call in or email us with your questions. And I see a question in the email regarding, it appears to be from a mother who has a son who's been arrested, indicates that what he committed was a petty theft. Reason he was charged with a robbery. Do you want to talk about how that can happen, lawman?
Yes, absolutely. Every crime, there's two parts. There's this part that's physical and a part that's mental. I have to want to do the crime. I got to intend on doing it, and then I got to do it. It's like in that movie Minority Report or Minority Report. They were trying to punish people for even thinking about a crime. But you can think about crime all you want, as long as you don't do it. So the difference between a petty theft and a robbery is huge, but it's very, very close. Because a petty theft means I walk in someplace or do any place. I grab somebody else's property, knowing it's not mine, and I take it and carry it away. And as I'm doing that, at the time I'm doing that, I intend on never giving that property back. So petty theft, as long as it's under $950. Grand theft, if it's over $950, but still a wobbler misdemeanor.
By wobbler, what that means is it can be charged as either a misdemeanor or a felony. It is at the discretion of the district attorney who is making the filing decision.
Or the judge in a 17B motion a little bit later. So that being said, a robbery is not much different. You have to take and carry away someone's property, but it's how you acquired that property. No one saw me steal the candy bar. But if I stole the candy bar and the owner says, hey, give me that candy bar back, and they block me from walking out the store, or they grab me and I pull away from them, any force or any fear I put into them in order to acquire that property now becomes a robbery.
It's force or fear or the threat of the use
of force or fear. Because I just say, if you come near me, I'll kill you in order to take away that property.
And that would be sufficient to change what started as just a petty theft of a minor item into a robbery.
Not a touching, no weapon necessarily.
No weapon is required, just that threat. So if I walked up to someone and said to them, if you don't give me your wallet, I'm going to beat you up. And they handed me their wallet, I could be charged with robbery, even though I never actually touched them at all.
Right.
But that threat, the words that I said formulated that threat, which caused them to be fearful and caused them to hand over their property to me.
And you see that a lot of times in liquor stores and things like that, where people would come in and dash out and try to take it, and they got to push by somebody, or somebody tries to stop them. Even in the parking lot, even down the street. So you're running, you're far away from the scene, but yet someone's been following, or someone says, hey, stop that guy, and that person, someone tries to stop you, and you, all right, get out the way. That could be the robbery. It was petty theft, grand theft, all the way up to that point.
Now, we will say that that issue with your son is something that hopefully the attorney would be able to negotiate it down to a lesser charge. The reason you don't want a robbery conviction, if you can avoid it, is that not only is it a felony, and it is not a wobbler, but it is also what is known as a strike crime.
Right, serious and violent felony. Even though no violence may have been used technically to do the crime, it's termed that simply by definition.
Yes, it is how the penal code section lists out the crimes that are defined as violent. So no violence actually needs to have occurred for a crime to be classified as a violent crime. If it is on that list of crimes in the penal code that are defined as violent, it is considered a violent crime.
So, and the law works that way a lot of times. There's a fine line, between a high crime and a very low misdemeanor. Kidnapping into false imprisonment might be another area where kidnapping is definitely a case a crime you can go to prison for. And some kidnapping for the purpose of some other action could be life offense. But false imprisonment could be just blocking the doorway and somebody pushes past you.
That is true. There's another email question, and that question is, my cousin was accused of a robbery and a gun enhancement was added. He did have a gun, but he never he never fired the gun at anyone. Why was he charged with the gun enhancement?
Well, we passed a law in California called 1020 Life. It is in the area of Penal Code Section 12022.53.
Now, let me just be clear. When lawman says we passed the law, it means the legislature, the state of California, because certainly we never would have passed a law like
that. Now, guess what circles back? Voting. Laws like that, 3 strikes will never get by if people voted, because it hurts our community the most. But that being said, the law was passed. 1020 Life was you heard it probably when it came out, because they were saying use a gun, go to prison. They were putting up billboards and stuff like that. Use a gun, go to prison.
I never actually saw billboards. I do recall seeing, in terms of billboards, none of the big ones along the freeway, I do recall seeing some media about it, like on the side of buses.
It was a slogan, yes. Yeah. And I think I saw billboards in Oak Park. Okay. I mean, it was weird, but okay. All right, maybe I'm in Oak Park more than she is. But nevertheless, that law meant, and it was strictly a gun enhancement type crime. It's not a crime itself, but it can enhance other crimes.
Meaning that it has a separate term of imprisonment that can be attached.
Right.
To the substantive crime.
And robbery is an excellent example. Robbery with a gun, because robbery is only worth 2, 3, 5 years.
2 years, 3 years, or 5 years in state prison, or you can actually receive probation. And at the time, it was up to a year county jail.
I've seen people get 180 days.
It was up to 5 years of felony probation.
Exactly. So 1020 Life meant, well, if you did commit a robbery, and just use of a gun, which is several different ways to use a gun in a robbery.
And I think we need to define that. So the legal definition in California of use does not require discharge.
Right.
It does not require that you actually point the weapon at anyone.
Right.
It is just in any way utilized that causes fear in the person that you're addressing. So, for example, if I walked into the Shell gas station and had a firearm in my waistband such that the person could just see the handle of it, and I said, hey, you know what this is, you see this, break yourself. That would be considered a use. I never pulled it out. I never pointed it. I never did anything specifically threatening with it other than to let them know that I had it. That is sufficient for the district attorney's office to file a gun enhancement against me under that fact pattern.
Definitely. And that is a solid 10 years, basically. Yeah. And, we had a statute 12022.5 that came before this. And what it did was it still kept the triad, 3, 4, and 10. So that's where the 10 comes from as the maximum punishment. But you go right to the 10 if it's a serious felony or a serious or violent felony. Now the 20 kicks in. And so let's be clear, the use is not how we would think about using it. But the legal definition just says the gun was displayed, showed, you can hit someone with it, anything can be used without discharge. So then that 20 comes in when there is a discharge of the weapon. Shoot it on the ground, shoot it in the air. But you discharge a weapon during that crime, now it's 20. And that's a solid 20. Okay.
Now, when they discharge it, does it have to actually hit anybody?
No, not at all.
Not at all.
And here's the real thing. What if you have a starter pistol, shooting blanks, right? So, or a pistol, yeah, and you got blank rounds in it. Does that mean that you discharged the weapon? And that's where it really gets interesting, because if in fact it's a robbery, you pull out your starter pistol, you hold it up in the air like if somebody's going to run a race, and you fire it. I don't know whether a projectile is going through the barrel or not. I'm not watching for that. It's still going to kick out possibly a shell casing if it's an auto semi, but in that situation, that could be discharge of a weapon, and that's 20 years alone. So here I get the 2 years for the robbery, and I get 20 years for discharge.
For a total sentence of 22 years in state prison.
And I think I got to do what, 85% of that, according to the strike laws. So then the 25 to life level. Now that kicks in when the weapon is used, discharged, and kills someone, or great bodily injury, actually. But you got to hit someone somehow, causing some kind of great bodily injury, which means more than just simple injury, okay? More than minor, as they say. When that situation arises, it's a 25 to life tag on top of the crime. So when we, as California citizens, pass the 1020 life provision, that's what we allow to, that's what the laws we allow to enhance regular other crimes, because these are only enhancements, which means it's not a crime itself, but it will enhance a crime that you're charged with. So if they, like she was saying, look, we would hope that the lawyer would be looking for some way of trying to express that the weapon, if not used, what was it being there for?
Well, there is a law that passed, and I believe it became effective in January of 2018, and that was it SB 620? I believe it was SB 620.
Yes.
It used to be, if that gun enhancement was applicable, the judge had no power to dismiss it, no power to strike it. And if the DAs decided to charge you with that enhancement, unless they changed their minds, you were stuck with that enhancement.
Right.
SB 620 changed that. And now judges do have authority and discretion to dismiss the allegation, to dismiss the gun enhancement, to give you a lower gun enhancement, or to strike the punishment for the gun enhancement. And that did not exist prior to 2018. Now, to take it right back around to what Lawman was saying about the importance of voting, there is a new bill that has been presented.
1519.
And 1509, AB. And so AB stands for Assembly Bill, and SB stands for Senate Bill. So there was an Assembly member, and I believe joined by 2 other members. Let me just see if I have that Assembly person's name here.
I think it was a Hispanic guy in LA or something.
But here it is. It was Assembly member, last name Lee, and co-authored also by Assemblyman Stone. And it's AB 1509. You can Google that, AB 1509. And that would modify gun enhancements to change it from 10, 20 life to 1 year, 2 years, or 3 years. That you could receive additional. Now, yes, that is still a punishment for a gun enhancement, but it is a substantially lesser punishment than what we have been seeing. And even though SB 620 gives judges the discretion to strike gun enhancements, it does not mean that they will.
Right.
And depending on the specific facts and circumstances of the case, meaning the more that the judge believes that the facts are egregious, the less likely that he is to strike or change that enhancement at all.
And it's similar to how the three-strike law has progressed, whereby judges used to have no discretion. And then they gave them some discretion and they gave them guidelines. So hopefully here, we're probably going to get some guidelines.
If it passes.
Yes.
Again, this goes back to the issue of voting. If we as a people don't contact our legislators and let them know what we want to see, what types of laws we want to see passed, if they don't hear from us, they won't know. And those laws won't pass.
They won't be supported. And it's funny, and that's where the irony comes in. It's as simple as voting, which is actually a very liberal process nowadays. It really is. A lot of people lived all of their lives believing they couldn't vote because they had a felony. And that's not true. All their lives.
Well, let me just say this. It varies per state.
Oh, sure.
So,
but I mean California.
Yes.
Here. Yeah. And to go to your Secretary of State website, usually will tell you about the laws regarding voting. So when one's in California, the only thing that precludes you is in state prison or on parole. That's it. Otherwise, county jail. You can vote.
Well, when you say county jail, you can vote. What do you mean by that?
Well, what I mean is if you are incarcerated in county jail.
So if you're in county jail and you're pending charges, but you've not been convicted, you've not been sentenced to state prison.
Exactly. That's the thing. See, it's state prison versus county jail. County jail would be the local county.
But what if I'm in jail?
Yes.
I'm awaiting charges.
Yes.
I've not been sentenced to state prison on this particular case.
Right. As long as you are not in prison, and that means in custody of CDCR.
What if I am on parole from a prior case?
That's when you can't. Cannot. Right. So it's kind of easy to remember, and the good part is if you're off parole in 18 months, 3 years max,
Well, there is going to be another election that is coming up in Sacramento County.
Oh, okay.
There is an election that will be coming up in 2022.
Okay.
So we're just saying, even though this is not a year for specific voting, this is still a year to develop and maintain relationships with your legislature.
Yes, as well as register. The registration part is actually
so that you can be prepared in advance and you're not scrambling at the last minute and worried about whether or not you can meet the deadline of being registered in time.
Right.
But we have to think ahead. We have to start thinking ahead if things are going to change.
Right.
And we have to start demanding change. And demanding change isn't always a protest in the street, although that is a way to do it. And we appreciate our community groups that have been actively involved in doing those types of protests and getting the people out. But another way of making change is through the legislature.
It's true. And the silent vote. Because who used to joke about that? Dave Chappelle used to joke about how individuals would protect that, who are you voting for? I'm not telling you that, but I'll tell you all this other stuff in my life, but I'm not going to tell you how I vote.
And you don't have to.
Right.
You don't have to tell someone how you vote.
Yeah.
But you do need to vote if you want there to be changes in your community. And it doesn't stop with voting. You can contact your elected officials with your concerns and what types of laws you want, what bills you want them to put forth, or making comments on your position regarding the bills that they have put forth.
Definitely. I mean, I guess, if you want society to change, if you want something to change and a vote can affect it, then it's a beautiful tool. But that's where gun enhancements hopefully will change. This 1509 is kind of wild, okay? For those who've been litigating these issues for 20 years or so, for those who saw 3 strikes come in, and its devastating effect, for those who see 1020 life come in and its devastating effect, this change will be magical. It really, really will. Now, one problem, right? Well, darn it, Keith, look, I want those gun laws to be heavy because I don't want nobody shooting my son. I don't want them to hurt my family, okay? I don't want them to get 3 years when they shoot my son, plus a 2, 5 years. I don't want the laws to be that light. I don't want people to get away with things. It makes it too easy now. There's no risk. There's no, well, if I do something, am I going to be harmed or punished? Harm. You got anything to say about that? What about that feeling and that position? Because we can all be on that side one day. What do you think about that? For those who say that.
I'm unfortunate. I would say this. Prison is not by any stretch of the imagination somewhere a place where anyone would ever want to be or want their loved one to be. Any amount of time in prison is a severe punishment. You are away from your family. You have no level of privacy. The medical treatment that you receive is likely to be substandard.
Yeah. And you're in the danger zone, really. It's a dangerous place.
It is a dangerous place because there are other people who are locked up, and part of the mentality that comes with being locked up, which can cause people to be a danger to other people. So I myself personally am not concerned about, well, I want the laws to stay as strict as they are because I've seen the damage that it does, not just to the individual that is sentenced, but to that family unit.
And therefore the community.
Because you will have the children of that person who is sentenced to 22 years for a robbery or 12 years for a robbery because there was a gun on their person, whether they, in the instance of the 12 years, whether or not they actually pulled it out and displayed it. Their children will grow up without them.
And that's always devastating to a community.
It is devastating to the community.
Our grandparents are raising the children. That's just not right. But it's almost necessary, that somebody's got to be there. And it's similar to, it's just like Michelle Alexander when she wrote the book, the New Jim Crow, and how we're developing this underbelly area where people have felonies and, they can't get services.
I wouldn't describe it as an underbelly area, but I would describe it as a form of second-class citizenship, which is, I believe, how she described it.
Yeah.
Where you have people who, if you have a felony, then you can't live in certain housing. Right?
With certain people sometimes. So where are you going to go? And you've got to shove them in somewhere. People got to live somewhere, somehow. So it's creating that.
Where they end up living is that it results in recidivism.
Exactly.
Because a person may get out of prison and they may have a family member who says, hey, you can come live with me, but it turns out they live in subsidized housing. And so they're not allowed to have that person there, so they can't let them come there and stay. And now that person who had a relative willing to help them has to live basically homeless.
Right.
And if you have to live homeless as a human being, you're going to do what you need to do in order to survive. And that, unfortunately, may result in them committing other crimes to be able to just feed themselves.
To exist. We've recognized that victims of sex trafficking are now being treated as victims when they commit crimes in the future, because we're looking at it as they had no, they almost had no choice. That's what they know. That's what they are used to doing. And as the crimes that they commit get worse, punishing them by putting them away and things like that is not favorable, in the long run, because they have a lot of PTSD pain and things like that from the experiences they went through. And so we try to look at that as a factor when individuals who have been trafficked are, commit crimes. Mm-hmm. And I know, I think it's the Bridges Network, I hear that tries to do a lot of work with ladies and things like that, and people are reaching out, and so it probably should be that same way across the board for individuals who really suffer. And they're only, sometimes your only outlet is that, go back to prison, or you take such risk, that
I think they have a term for that.
Recidivism?
Well, yes, that is, but I mean, refer to it in the
life on the installment plan?
That, or taking penitentiary chances. That's what it's called. Taking penitentiary chances, and that's doing things that are risky and that might wind them back up in prison, but that they have to do to be able to survive. Right. We shouldn't want to put fellow human beings in that type of position.
Correct. And so, let's see, what were we talking about before we got on that? Voting, everything will come back to voting and stuff, and what we want as our laws. I mean, I'll tell you something. We were talking before the show about our Supreme Court, right? The highest court of the land, the court that says in Florida v. Royer in 1983, you don't have to talk to police officers at all. And your lack of talking to them is not reasonable suspicion to detain you. That's a beautiful court case. I use it all the time when I'm talking, because I want people to see that the Supreme Court in the land in 83 said, this is the way the law works. It's the whole genesis behind developing the relationship with the cop when you see them. As in, am I free to go? Because you've got to develop the parameters at which you're working. And that's all you have to say, because if you're not free to go, an officer needs reasonable suspicion.
Again, you're not going to know whether or not he has that. But you ask if you are free to leave if you are in an encounter with law enforcement, if law enforcement stops you, if they yell and say, hey, come here.
Because you never
Don't just
have
walk
to talk
over to them. Ask, are you free to leave? Now, he may curse at you and say, no, you're not free to leave. That is then your indication that you need to assert your right to remain silent. You're not required to answer his question at all.
Right.
And to assert your right to an attorney.
Right. Now, so that's that is so powerful. And it came from our Supreme Court, just like Plessy v. Ferguson, which said that, you got just a little bit of black in you. You're black and you're substandard. Okay? You're not a human. So that came from our Supreme Court too. So our Supreme Court can do all kinds of things, and it can swing one way, it can swing the other. And we have to really, really be aware that voting can sometimes trump the Supreme Court. Meaning, if the Supreme Court made a ruling and our legislators, following that up, create a law that passes muster, meaning it's not unconstitutional, that also becomes the law of the land. So how a legislator may go around the Supreme Court's decision and create laws that we then will pass because we want them to stand. Let's see, where did that happen? I don't even remember.
We have another. Oh, go ahead.
No, let's do the question.
Okay. Yeah. Another question, and that question is regarding a burglary. It indicates that his brother was charged with a burglary, but they are trying to give him 85 or have him serve 85% of the sentence instead of 50%. And how is that possible?
Probably on the type of burglary that we're talking about. Okay, there are different types of burglaries. The first and low end burglary, we call it second degree burglary. And it's second degree because it's everything except for a dwelling. So, storefront, garage, detached garage, sheds, schools, right? Things like cars. If you break into those things and take something, second degree burglary. They're actually wobblers. Could be misdemeanors, could be felony. That, never a serious or violent crime, not even a mandatory prison crime. And you can commit a lot of them at once, and yet still not go to prison. Now, tell us about the other one.
I wouldn't say that you could commit a lot of them and not go to prison.
Oh, all right.
And there are plenty of factors that determine who goes to prison and who does not go to prison. And we will say that discussion reason is the classification of the burglary. If it is a residential burglary, and the person has been sentenced to a state prison for that, they normally would receive 50% credit. However, if someone was home at the time of that burglary, that changes the classification of that residential burglary. It is still it is still a strike crime. It is, but it changes it from being a serious felony to being a violent felony. In order for that to happen, the district attorney has to specifically allege, and the person has to admit that someone was in the residence, meaning someone that resided there, or someone who had permission to be in the residence was in the residence at the time that the burglary happened. It does not require that the culprit, the person doing the burglary, actually has contact with the person in the home at all.
Exactly.
It just requires that they be in the home. So if I were to go inside of someone's home with the intent to take property or commit any other felony, and let's say I'm in there and I'm going to steal jewelry, right? And someone in the home is napping in a bedroom. I never have contact with them. They hear me rummaging around and they get their cell phone and they call law enforcement, and I'm arrested, down the street or leaving the house. The mere fact, and there was never any conversation between me and the person in the house. The mere fact that they were in the house can be alleged. It's under Penal Code Section 667.5, subsection C, subsection 21, I believe. And so that change would then make it a violent felony, which then limits the state prison credits that I can earn, that are referred to as good time credits. So if the person was not in the home, I would only have to serve 50% of my sentence and I would receive 50% good time. If there was a person in the home and that was specifically alleged in the complaint, and either I was convicted of that allegation or I admitted that allegation, now I'm only entitled to 15% good time. I must serve 85% of that sentence while I'm waiting in county jail. And then once I get to prison, pursuant to Prop 57, it's increased slightly by 5%. I get 20% good time credit. I have to serve 80% of that sentence.
Our sentencing laws, no, and not everyone can master them or understand them, but you got to know they're there. You kind of got to know, and that's a big difference. That first degree burg, especially when you don't realize someone might be in a home. So until you're in there, now is there something you can do to prevent that from happening when you roll in and you see somebody's in a home? What do you think that you can do? Is there any way to prevent that?
Don't do the burglary. That's the way to prevent it.
What if they withdrew? What if they said, "Oh my goodness, somebody's here. I am out of here. I didn't mean to burglarize. I'm gone. I'm gone. I'm gone."
Unfortunately, your intent is the intent So it would not matter that you did not actually take property
Right.
if you entered the home with the intent to take property. Now that's going to lead to the question, how does someone know my intent, right? They can't look inside of my head. How do they know my intent? Well, it's going to depend on the surrounding circumstances, the surrounding factors. Was this the home of a stranger, right? Versus the home of a friend. If it's the home of a friend, perhaps you have an explanation as to why you went in the home. Also, how did you get into the home? Did you break into the home? Did you use something to pry the door or pry a window? So it's the surrounding factors that will help to determine what your intent was at the time that you entered the home. But if you entered the home with that intent, let's say I pried the door open, I went inside, and then I decided, oh my God, someone's here, I better leave, that could still be charged at that point as a burglary.
What you're trying to do is negotiate it down. Of course, if they threaten, burglary with the individuals in the home, you kind of want to ratchet it down if you can in part of the negotiation. But that's a good. It's a good example of how burglary can slide up and slide down, depending on what kind of power is behind it. So let's see, where are we? 6:51.
We have another question regarding an attempted robbery. It states, my brother went into a home. The homeowners were there. They demanded property from the homeowner, but the homeowner didn't provide them with any property. They actually didn't get anything, and they left. How is that still charged as a robbery? Also, the person in the home lied and said that my brother had a weapon when he did not, and my brother has been charged with a gun enhancement. How is that possible? There was never any weapon found when he was arrested.
Well, are we answering that one? Okay. Well, narrow it down. Give me one before the other. Give me right.
So I guess the first fact is they didn't get any property. They went in, they made a demand for property, but they didn't actually get any property. How are they charged with a robbery?
The force of fear that we talked about earlier.
But they didn't actually get any property. I think in this instance, and again, we have limited facts when we're reading a question, what probably happened was the alleged victim said that there was some property that was taken. And so you can have that happen as well. Sometimes people may not be truthful about whether or not something was taken from their home. That could be just because they're very angry about the intrusion that occurred in their home.
And we're talking about the attempt. Now I go in, I say, give me your stuff, okay, and you don't give it to me.
Then that could be charged as an attempted
robbery. And what attempt means is that I've taken more than a small step towards committing that crime, but the crime was not committed.
Was not fully completed.
Exactly. Meaning property taken in the robbery situation.
Now, what about the fact that the emailer is indicating that their brother did not have a gun, but is charged with a gun enhancement? That would lead me to believe that, again, the victim made a statement or an allegation that your brother did have a gun. And even though he may not have, if the victim makes that allegation, the district attorney is going to make their filing decision based upon what the victim is saying. And unless there is some prior interaction between them that would show that this victim has a specific motive, specific bias to lie about your brother, the district attorney is going to file that enhancement. And that's the kind of, in those instances, those are the kind of cases sometimes that have to proceed all the way to trial. And your brother may, because at trial you have a right to testify. And sometimes you have to decide what's more important, right? In that particular case, it may be that the person would admit, yes, I did go there with the intent to take property, but I didn't have a weapon.
Right.
And if the jury believes them, if they are believable, the jury may not convict them of that enhancement.
Yeah. And
now, the opposite also applies, though.
Hmm.
The facts could really be that your brother did not have a weapon, but the victim testifies that he did, and they believe the victim. And so that is a circumstance where someone can be convicted of one of these extremely serious gun enhancements, even though they didn't really have a gun.
yeah.
Now, there's another question. Does the gun enhancement apply if it was a air pistol? I will let you answer that, lawman.
So a fake one, a BB gun, a pellet gun, interesting. Yeah. You know, I mean, I've seen it both ways in a way. If I am wrong and I feel that, and I really don't see it, but I have every reason to believe you've got a gun to my head, and it's not obviously fake. Meaning, that's why they started making the pellet guns with the red in the barrel and everything.
But people can paint over that.
Absolutely.
So technically,
right.
It only applies to real firearms. But when crimes occur, sometimes the person does not know whether or not the firearm is real, and they believe that it is real, and their description of it matches the description of a real firearm. In that circumstance, a person, again, could be convicted if the jury believed the testimony that the firearm was real.
And so that's why when people say, well, it wasn't a real gun, it wasn't this, it wasn't that, you try to sell it as a lawyer. You try to, hey, it was obviously not real.
Well, I wouldn't say sell it. You try and put forth your client's position. Well, sometimes people think selling means that you're telling them something that's not true versus something that is true.
Okay, then good clear up. All right, but at least whether it's true or not, the lawyer actually has to make that argument that, hey, this was obviously a fake gun.
And one of the ways that can be done would be if the person knows I still have the fake gun. It's hidden in my drawer.
Right. And they take a look at it.
Let your attorney know that. They'll send an investigator out. Turns out.
Take a picture.
Yeah. He had a fake. It was an air pistol.
It was red and plasticky. I mean, just whatever.
And again, let me just say this: there are air pistols that look exactly like real firearms. Yeah. So much so that there have been law enforcement officers who have not been able to determine the difference.
Right. I guess that would be the situation in Cleveland with the young boy,
Tamir Rice.
Yeah.
Well, that officer he wasn't trying to determine anything. He got out of the car and he killed that child within a matter of seconds, not minutes, seconds. So he was not trying to make a determination. He saw brown skin and assumed criminal.
Yeah. But he was a little boy.
Obviously the officer didn't see him as a little boy. Apparently, when they see brown skin, it changes a child into an adult. We know in reality it does not.
True, but it would be seen through the eyes of that officer. He'd see what he wanted to see for that moment in time. I mean,
well, what do you mean seen through the eyes of the officer?
Meaning
there was no reasonableness in what he did. I don't care what they tell us. There was no reasonableness in what he did because where he responded was a playground. Was it not a park?
A gazebo-ish.
At a park where children normally play.
Right. Now, I don't mean children ain't been playing with guns, but I'm just saying.
He gave no opportunity. No opportunity whatsoever.
That's what I mean by it's the view of the officer. The view is narrowed to the point to where he was only going to see that gun as real. Period. That's all he would.
Then that's a problem with his mindset, not with the situation.
Oh yeah.
And I'm not even sure that he actually observed it. He's operating off of the phone call that they had received by someone saying, I think someone. And I think the person may have even said they didn't know whether or not it was real. And apparently I don't know if it was clear or not. I don't know if the dispatcher communicated that specific fact to the officer, but the officer is capable of seeing what dispatch is entering in the system. So if dispatch entered that and it showed up in the dispatch logs, he should have seen that.
Yeah, he should have. I mean, that does, what I'm saying is, look, some peace officers use I'm very stressed in my position. I see a lot of things. I have to react quickly. I don't have time to process everything.
Well, then you shouldn't. If you don't have time to process, you shouldn't be out there. It's not as if the child was pointing the gun at him.
I don't know that as an officer.
You do know. You can see that it's a child, and they're not pointing it at you, and you've given them no instructions.
All I see is a perpetrator, an individual.
Well, then that's a problem with law enforcement.
But see, this is what I'm trying to say, is that it goes much deeper than the officer, a simple analysis of whether the gun is bad, or real, because he will never see the gun as being fake. You can never see it that way.
Then if that's the case, and that explains then why on occasions when people haven't even had guns and have had encounters with law enforcement and not been able to survive those encounters.
Knives and anything else, a crowbar.
And so then that is a problem in training, and it is a problem in the United States.
It is, no doubt. But when it comes to a fake gun, I mean, I'm just saying that's the excuse.
Well, that's that. Let's not use that circumstance because.
Mommy, I know.
It's not just a mommy. That's just what happened there should be offensive to anyone.
I mean, how quickly the decision is made, to do that, to use force.
But that decision then was based on that child's race. Had he got out of that car and that been a white child, would he have shot that quickly? Because it is seconds. And it's on video. So it's not just someone's word about what the time span was.
Now, and I'm going
to So basically, people of color are transformers. We have guns when we don't have guns. We can transform our hands, our arms, our legs, our cell phones into guns.
Beast. We can be, right? I mean, think about it. Just being big is a threatening thing. I'm not saying it's right, obviously. I'm just arguing with her, okay? Because just to try to throw this other side.
But even being small, apparently it is just being a person of brown skin.
And that could be.
And that needs to change.
Yes, it does. Now, are we going to do it tonight?
We're not going to be able to do it tonight.
Dang it. I'm ready for some change tonight.
But again, we do want people contacting, find out who your elected official is. Contact them about AB 1509. We need to get that passed. And we need it to be, and I believe they've requested that it be retroactive so that we can bring the many, many, many young men home who went to prison at age 18, 19, 20, 21, with sentences of 12 years, 15 years, 20 years, where they will spend, if the current law stands, they will spend most of their productive years, the years when you're supposed to be growing, developing a career, raising your family, becoming a man in prison.
And it's so, and so I argued about the victim side just so that the victim side is there. But this is bringing back people who, when you look at the act that actually sent them there, I've seen guys use the gun. Hey, you're robbing people they robbed me last week, so I'm going to rob them this time. Like it's a game. So you're doing this hard time for that game. So individuals where there is a robbery, there is a use, there's a crime, but there really was no injury, harm. That's what that is for, I believe.
We have a comment for Borkai, who missed the beginning. AB 1509 is a new bill in the assembly, which would modify the current gun enhancement sentencing which is currently 10 years, 20 years,
life.
Or life,
right.
to 1 year, 2 year, or 3 years. And there probably will, in the end, if it does pass, there'll probably be some specific crimes that are accepted from that.
Oh, yeah.
But right now, we have so many young men who are serving those extremely long prison terms for something that they did when perhaps they were intoxicated, or as a result of peer pressure.
Right. Gang.
And justice doesn't mean throwing someone's life away because they made a stupid mistake. We've all made mistakes. You show me a person who has not made a mistake. They just made a mistake that was classified as a crime. But we don't need to throw them away.
And we do these things. We create a blanket crime, and we forget that it should be an individual life and sentence, in terms of sentencing. Look at the individual.
Yes, there's an additional comment. Yeah. The training kicks in with non-brown Black people. And I think she's referring back to the officer and relying on specific training before just automatically going to shoot first, ask questions later.
And that's what I mean is his program to the extent he could not see that's a non-dangerous situation.
That's not the result of training. What programming is that?
I'm not saying result. No, that's that person's life in society, right? That's the lack of a training, like she says, and being able to discern such things and be able to.
But how is it then that they could discern it and take the time when the person is not a person who is
because
color?
Exactly my point. That's because that is what they will see when they arrive on the scene and they see that color, they see that situation, they automatically are, oh, okay.
So then I believe that there have actually been studies. I recall an eyewitness expert that I utilized before talking about specific studies they had done where they would show the study subjects photographs,
right.
And they would show them a variety of photographs of different people, and then they would ask them which person had the weapon.
Yeah.
And it actually, in the photograph, would be the white person who had the weapon, but for whatever reason, more likely than not, they would always choose the person of color,
yep.
The African American person,
yep.
Even though they were truly and factually not the person with the weapon.
That's exactly what I'm talking about. See, his ability to see. It's totally the individual person.
It's wanting to see.
Well, now wait. See, they don't want to see. That's why we have the problem.
That's what I'm saying.
Yeah. I mean, all right, we're on the same page.
We are on the same page. But man, we have come to the end of another episode.
Oh no.
And in fact, we've kind of gone over time, but we started 3 minutes late. So we're almost on time.
Yes.
What tidbit do you have?
Okay. Sunday between 3 and 6 at Stefante Clark's Stefan's house. They've asked me to talk about some issues. Yes, they call it Sunday, Stefan's Day Sunday.
Okay.
And I'm going to talk about voting. I'll talk about changing the laws through voting.
Now, is this going to be a Zoom?
I'm not sure. You might get on his Facebook page. I don't have total details, but
okay.
You can Google and see.
So Google Stefante Clark.
Yeah, and his Facebook page or anything like that.
Okay.
It
may also be posted perhaps on the Black Lives Matter website.
Sure. Well. But he asked me to come in and talk about the things I talk about all the time, which is knowing your rights, how to deal with cops, and voting. And it's a perfect opportunity because I feel like this is something that we should all be very passionate about, and I am passionate about because I can watch it happen. We've seen the difference occur. So I hope to offer a lot of tidbits and things and encouragement and inspiration.
And that's from 3 to 6
3 to 6. I don't think I'm doing the whole thing, but because other people, but definitely I'll be around. Yeah.
Yeah. And that's Sunday,
this Sunday, April 4th. Yes.
Okay, so they can Google that
online. And I'll probably record it or something. Somebody will record me so that I can pop it off in here and there and everywhere. Because I hope to do something that's kind of comprehensive, that just really something that anyone will learn how they can make a difference doing a very small thing. and how we should move at this particular time, because this is crucial. The George Floyd trial's going on. We're watching things like the Major League Baseball pulling out of Georgia. You know, we're seeing things that you know, truly I never thought I'd probably see in terms of changing in the law even. And so it's a nice time. It's a good time for us to stay on the attack, as they say, to stay diligent and protect our communities.
And I would just end with a quote from W.E.B. Du Bois, and that is either America will destroy ignorance or ignorance will destroy the United States.
Right.
And we don't want that, people.
Ours.
It is ours. We built it.
Right.
So this is the end of another episode with Lawman
and Carmen B.
Thank you so much for joining us.